Now, let's go to legal assistance and case management naman. For the legal aid services, the law clinic shall determine the type of legal assistance it shall offer. Now, such assistance may include, but shall not be limited to, legal advice and consultation, legal representation, which includes legal opinion, opinion as counsel for the party, or negotiation, and acting as a neutral and independent mediator, conciliator, arbitrator, among others, and, of course, developmental work like assistance to LGUs, NGOs, and government agencies, advocacy of specific public interest issues or for specific legislation, popularization of legal aspects of current issues, and information dissemination. Now, please note that this list is not exclusive. These are just examples. So, these are just the types of services that a law clinic may provide. Now, the law clinic may use the following activities to enhance the legal aid service it provides. So, ano yung mga pwedeng gamitin? Personal consultations, role-playing, seminar, workshop, and forum, voice and online assistance, especially in this time of the pandemic, no? Between walk-in consultations and online, nandito na tayo sa online platform na we're developing that. That's the reason why nga even our lectures are now online because it's actually safer. So, the law clinic, in order to enhance its services, may focus on online assistance. Okay? Now, communication materials such as short manuals, flyers, pamphlets, short video clips, radio, TV, live streaming, etc., policy lobbying, jail decongestion program, preparation of legal documents, and others. Okay, so again, this list is not exclusive, and if the law clinic may be able to come up with other activities to enhance its legal aid services, then it may do so. Now, for the evaluation procedure, you may have a provisional acceptance of cases. No, pwede naman yan na hindi agad at the start pa lang, maka-interview pa lang, accept nyo na agad. You may have a provisional acceptance of cases pending verification of the applicant's indigency and an evaluation of the merit of his or her case. But ito nga, kaya siya provisional acceptance because it might happen that the law clinic will not yet accept the case, no? For example, of a particular applicant, but since it's urgent, there must be a provisional acceptance. So, kailan po yun? In cases of warrantless arrest and inquest proceedings, where a warrant for the arrest of the applicant has been issued, where a pleading has to be filed immediately to avoid adverse effects to the applicant, where an appeal has to be urgently perfected, or a petition for certiorari, prohibition, or mandamus has to be filed immediately, and other similar urgent cases. Okay? So again, the law clinic is not mandated to immediately accept a particular applicant. Kasi nga, kailangan i-verify pa ng law clinic if the applicant meets the criteria of the law clinic for accepting cases, for example. But there may be a provisional acceptance. Okay? And the criteria for that naman, or the element for the provisional acceptance, will be the urgency of the situation, the ones that I enumerated earlier. And again, obviously, it's not an exclusive list because we made mention of, or we have that general term, other similar urgent cases. Key element here is urgency. Okay. Now, the manual also provides an item or a section on the approval or disapproval of the application. It is to be made by the law clinic director based on the PIF. Ano ulit yung PIF? It's the preliminary, not investigation, preliminary interview form. Okay, kasi kumpleto po ang details na. And I would encourage you at this point to look at the PIF. Tignan nyo, especially for the law clinic directors who are now watching this video, please get a copy of the PIF. and see if based on the details there, you may be able to render your judgment or your decision as to approve or whether you would approve or disapprove a particular application. And of course, based on that, no, you have the PIF, the Law Clinic Director will consult the SL if needed. Kumbaga, kulang or meron siyang gustong i-clarify dun sa PIF, then consult with the SL. The Law Clinic Director shall act on the application for legal assistance within a reasonable time, taking into account the complexity of the case and the length of time needed to review the records. We did prescribe a specific period for this kasi nga iba-iba po ang pangangailangan niyan. Maring isang case, mabilis ma-decide, pero isa super complex, hindi pwedeng mabilisan ang desisyon. So, we just stated it should be within a reasonable time. Now, the LSP shall then fill out the notice to applicant regarding the action taken form. Again, it's one of the forms that we have already drafted for you, indicating therein the reasons for accepting or not accepting the application, and turn over the same to the SL or legal or law clinic director for signature before sending it out. Okay. So, yun. May action na, then the next step nga is to fill out this notice to applicant regarding action taken form. Now, if the matter or the application is accepted, the law clinic director shall assign a handling LSP on the case or the matter. If it's rejected, the applicant shall immediately be informed of his or her other options for legal assistance. Now, please note that the law clinic director and lawyers of the law clinic are prohibited from taking on in their private capacity the cases that were not accepted by the law clinic. So, hindi po pwede yun, no? Yung sa rejection natin, if you reject the application, hindi nyo pwedeng sabihin dun sa rejected applicant na since the law clinic cannot accept you, you may want to get my services personally or our law office can actually help you on this. No? My private law office can actually help you on this. Bawal po yun. You don't do that. Okay? And it's important with sa rejection especially, that the applicant is immediately informed of such rejection. And how do we do that? Or how does the law clinic do that? Via the speediest mode available. Kasi nga, para makapaghanap na agad or ng options itong si rejected applicant. Kumbaga, kung sa love life yan, pag nabased ka, makapag-move on ka na agad. Diba? Parang ganon. So how will the law clinic give that information regarding the rejection of the application? Through text, email, phone call, or similar means. But aside from those, kasi nga ito palang heads up, a written notice must also be sent. Okay? Whether personal, registered mail, or courier. And actually, kahit yung acceptance, dapat naman yan may formal din na notice to the applicant that, the application. Yung notice to applicant natin regarding action taken, that will be sent out. That's the formal notice. So don't think that the notice to applicant is only for the rejection. It's also for the acceptance. But what I'm talking about regarding the speediest mode available, immediately notifying the applicant of the action taken, that is more important for the rejected applicants. Kasi nga para Now, please note that the referral system should be with the applicant's consent, and the referral may be made to another law clinic or other legal aid provider, such as the local chapter of the IDP, the Public Attorney's Office, or the alternative law groups and other civil society organizations. Now, what will be considered in making the referral? Geographical proximity is one important consideration for that, as well as the skills and expertise and other sectoral concerns. Now, when may cases be referred? When there's no available supervising lawyer in the clinic, and of course, if it requires a specialty practice and the law clinic does not specializes in that particular concern that was referred to it by the applicant, And when the law clinic director deems it urgent and necessary to make a referral. So parang the buck stops with the law clinic director. The law clinic director has a discretion and authority to determine whether a referral is needed or required and necessary. Now, what is the referral process? The law clinic will communicate with the partner law clinic to assess the referral of the case and consider if it's viable. If it's viable, then the law clinic director will prepare and transmit a referral letter stating the reasons therefor. And the attachments will be application form, the consent for referral signed by the applicant, and the documents submitted by the applicant or clinic. Now, earlier I said only a partner law clinic, so let me correct that because it's actually a LAP. What is a LAP? A legal aid provider. So it's not limited to a law clinic, but the ones that I mentioned earlier, even be a chapter of the IBP, etc. Okay. The law clinic and the partner lab, and again, that's a legal aid provider, will have regular coordination for purposes of assignment of the LSPs or the law student practitioners for monitoring and feedback. And what if it's a referral now between law clinics? It follows the same process of assessment and subsequent referral. Now, what are cases that are not referable? For cases involving conflict of interest, the law clinic director shall not accept such cases for referral within the network. Okay, so those cases involving conflict of interest will not be referred for referral within the network. Let me just emphasize on that. Now, for a more detailed procedure of the referral process, please refer to the law clinic referral network protocol because we do have that, and it is covered by another presentation. These are the grounds, no? So first is the failure of the client to fully and truthfully inform the law clinic of the client's economic status and existence of other cases, if any. Truthfully reveal without reservation the matters related to the case and inform the law clinic of matters which might materially and or adversely affect the outcome of the case, as well as securing and providing the law clinic copies of all pertinent documents, including transcripts of stenographic notes, orders, notices, and other papers from the courts. Okay, so ito po yung mga failure, no? And failure as well to pay the litigation expenses if necessary, to meet or discuss with the assigned LSP or supervising lawyer when requested by the law clinic, to maintain confidentiality by disclosing any matter in relation to the case to the media, like TV, radio, SOCMED, or social media, unless otherwise authorized in writing by the law clinic director. And appearing in hearings or proceedings where his or her attendance is necessary or required, and inform the law clinic regarding the client's intent to change his or her residential address or contact details or intent to leave the country. Now, please note that the absence or lack of response to any communication sent by the law clinic may be construed as proof that the client left the residential address and that the client is no longer interested in the services being provided by the law clinic. Now, for this particular failure, alright, kasi yun po yung first natin, di ba? Failure of the client too. What have you noticed here? These are actually the duties of the client, no? So when there's a failure of the client to meet his or her respective duties as enumerated, no, then that will be a possible ground for termination of legal services. But aside from that, another ground for termination of legal services is existence of conflict of interest. And securing the services of another counsel, that's another ground for termination of legal services and other analogous circumstances. Now, what will be considered as other analogous circumstances? Can you think of any? Alright. Sige, isip lang po kayo, ano po bang po pwedeng other analogous circumstances? So, po pwede po dyan, no? If you've thought of forum shopping, yes, that is an analogous circumstance. Non-disclosure of all the parties involved is another analogous circumstance. use of the applicant as proxy for another party, all right? Non-disclosure of political background or agenda of the applicant, yung may mga hidden or ulterior motives na tinatawag, among others. Again, ito pong list na ito is not exclusive. And if your question is, can the law clinic come up with other specific grounds for termination of legal services? Yes. Depende rin po sa ano ba yung pinaka legal aid na ino-offer ng clinic, no? So you may come up with your other valid grounds for termination of legal services. But it's important to note that the law clinic shall duly inform the client regarding the termination through the notice of termination of legal services form. Now at this point, can you please look over the forms that you have and see if you have that notice of legal termination, legal services form? Because it's also a form that we have drafted and crafted for you. So it's there. If you want to terminate the legal services of the law clinic, then you have to send out that particular notice. Now, earlier I mentioned about conflict of interest as a ground for legal termination. So, ano ba yung conflict of interest? Let's look, no? Let's look at the discussion that we made there in the manual. There is conflict of interest when the acceptance of new relations prevents or tends to hinder the law clinic from the full discharge of its duty of undivided fidelity and loyalty to the client, or if such invites suspicions of unfaithfulness or double dealing in the performance thereof. So yun yung parameters that we have included for conflict of interest. And the law clinic is supposed or has a duty of implementing measures to avoid not only actual but also potential conflict of interest. Okay, yun po yung requirement natin, no? The LSP, in consultation with the SL, shall identify any actual or potential conflict of interest at the earliest possible opportunity. And when is that earliest possible opportunity? Kung onset pa lang, application stage pa lang, nakita ni LSP, may possible conflict of interest na or baka nga after conflict of interest na. Then, pag meron ganun, of course, conflict of interest at that point will not be a ground for termination of legal services, but possible rejection of the application. So, yun po yun, no? And the LSP and the SL shall then refer the matter to the LC director for proper evaluation and resolution. The LC shall not accept applicants or maintain engagement with clients when the opposing party has previously discussed with the law clinic the merits of the legal issue or case. The applicant has a case or intending to file a case against the college or university. The applicant has a case or intending to file a case against a funding partner of the law clinic or the college or university. The law clinic has an interest on the legal issue presented, which is adverse to that of the applicant, and the law clinic director has a personal interest in the legal issue presented, which is adverse to that of the applicant. There is conflict of interest under the Code of Professional Responsibility, Local Government Code, and other applicable laws, or there exists any circumstance analogous to the foregoing. So, ito po yung mga naka-provide na grounds, no, for the law clinic not to accept or maintain engagement with clients. Alright? So, not only for termination, but also for acceptance. Okay. Now, please note that upon determination of the existence of a conflict of interest, the law clinic has the duty of informing the concerned applicant or client of its existence in writing and decline the application for legal assistance or withdraw its engagement as counsel. So, again, ito po, how soon is this? How soon should you inform the applicant or the client about this conflict of interest? Earliest possible opportunity po yan, not to exceed 1 week, no, from the time of the decision to either especially if it's a termination, ground for termination. But if it's for not accepting the case, then sabi nga natin kanina is the earliest, soonest, or the earliest possible opportunity to do so, or soonest possible opportunity.